You are watching Morning Musings with Reinhard von Hennigs, chairman and founder of BridgehouseLaw in Charlotte, North Carolina.
What is the FCPA? Hello, this is Reinhard von Hennigs. The FCPA is the Foreign Corrupt Practices Act. The acronym for that is FCPA, and it is right now heavily discussed. Why? The US president has issued an executive order temporarily halting new enforcement actions under the FCPA. This move has sparked a widespread debate over the international business community. The order, citing concerns over the American economic competitiveness and national security, signals a potential shift in the US government. The practice of condemning illegal practices abroad was implemented by the FCPA, and right now it is up for the discussion. For global business leaders, the question is rather, is this a necessary recalibration, or is it actually risking to undermine the very principles to ensure fair competition in international markets? The FCPA is, in a way, a double-edged sword. It was enacted in the year 1977, and it was a groundbreaking piece of legislation. It was designed to combat corporate bribery and to promote best business practices, fair business practices on a global scale. The FCPA was enacted in line with other anti-corruption laws globally. It was similar to the United Kingdom, to Canada, and to the European Union. Critics, however, argue that the enforcement right now in the United States had been way beyond its initial original intent, and it would give American companies a disadvantage. The executive order now suggests that the argument in the United States that this is detrimental to United States companies should be heard, and therefore now the enforcement of the FCPA should be set aside. But there are legal and economic implications. What comes next is a question. From a legal standpoint, the executive order could face significant challenges. The FCPA is passed by Congress, it is a law. And while the Department of Justice has a discretion over the enforcement of that, and of course the president can instruct the enforcement, but outright halting a new law could be challenged by the overreach of the executive power by different parties and challenged in court. In this litigation, it may be discussed how it shifts or how it aligns legislative intent and how the international obligations by American companies would be changed significantly. It is also on the economical front a discussion that while some companies may see economic benefits on the short run, on the long run, it broadens implications, and this may be a not favorable implication. Multinational corporations right now rely on a clear set of rules. And this predictable legal framework is right now, with regard to foreign briberies, set aside. While the United States appears to be backpedaling on the anti-corruption enforcement on a global level, foreign investors may question the credibility of compliance commitments. Global partners of United States companies may demand stricter safeguards, and FCPA similar rules may be enforced against American subsidiaries where they operate based on the local laws. So the fact that something may not be enforced in the United States may still not block the enforcement of similar rules in other parts of the world. So the risk could be that in a world of corruption, and even more important in a world of anti-corruption, that different rules are applicable for different parts of the world, which on a global scale is not a good idea if it comes down to ethics. So why should global CEOs, global entrepreneurs, global business leaders care? Enforcement, of course, and a relaxed enforcement reduces compliance. So it may be easier, it may be less costly, and it could also be advantageous to make a fast decision in a high-risk market. On the other hand, it may lead to an increase of foreign investigators, of foreign regulators, of foreign compliance, because a company which was safe before may now be under a higher scrutiny by a foreign anti-bribery commission or an anti-bribery authority. So while companies are subject to a very transparent, ethical business practice and also subject to multiple laws in all different parts of the world, the fact that one country is changing the rules may not really reduce the administrative and governance burden. As the legal landscape evolves, one thing is clear in my mind. Global businesses do not operate in a vacuum. Global business operate in an intertwined world. The balance between economic competitiveness and ethics is a delicate balance. And any disruption of this balance is changing the equilibrium, could reshape international trade for years to come. In a world where global business people ask themselves how to be more profitable and how to have a stronger market, the fundamental question is not about regulatory compliance. The fundamental question is about the true nature of competition. Is it really possible to gain global markets appreciation and global market share without compromising your integrity?
Whether you're a private citizen, an international business leader, or simply someone eager to stay on top of the latest news, this book is a great way to get caught up on the most recent developments in the worlds of international business, tax, politics, and social affairs. Go to morningmusings.com and order your copy today.
Thank you for joining us today. If you would like more information about Bridgehouse Law, please visit our website at bridgehouse.law. Before you go, make sure to like this video and subscribe to the channel for more up-to-date content. Bridgehouse Law, business-minded, client-focused.